Mr. Hinojosa, if this were a Title VI case and there was an allegation of discrimination against the University of North Carolina, who would bear the burden of coming forward?
Is it within the strict scrutiny?
No, just Title VI claim of discrimination.
A normal claim of intentional discrimination,
Exactly.
Your Honor. I would understand that the plaintiff would have that burden to demonstrate.
To come forward initially, but then when the plaintiff makes his or her showing, then what? What's the duty of what's the burden on the accused?
Well, it's not entirely clear from the case law that I'm aware of, Your Honor. Ordinarily,
Is there any case where the court has deferred to the university or to the alleged discriminators' policies?
So, for example, I don't know whether or not this has been answered directly in Title VI case law. Title VII case law, yeah. Your Honor, yes, then the burden would shift to, in that case, it might be the employer. What's
interesting here is I cannot think of another area or another case where the court deferred to the alleged discriminator on something as important as compelling interest. We don't do it in Title VI, we don't do it in Title VII. You have McDonnell Douglas, you have Arlington Heights, and this is a first. And what I'm asking you is, isn't it odd that you have a framework in Grutter that defers on the critical issue in the case of compelling interest?
No, Your Honor. I think it's entirely consistent, with this case, with this court's framework in judging strict scrutiny. Let me make a couple of points first. One is on the discrimination point. This is not discrimination per se. The limited consideration of race in a holistic fashion, as this court has approved, is a limited classification that is subject to strict scrutiny, but that whole strict scrutiny process is trying to filter out whether or not that we have a legitimate purpose for this or not, and whether or not there's a compelling interest that may be sought and achieved, through narrowly tailored means.
Let me ask more specifically. If this case involved a school district in Virginia in 1960 that is alleged to be discriminating, would this court defer to its assertion that the races do better if they're segregated?
Absolutely not, Your Honor, but that's not this case. This case is about a limited classification involving a compelling interest.
That's not what I'm talking about. I'm talking about the court's deference. In that case, the court would put Virginia to the test. In this case, it does not. And I'm asking you why the difference.
In this case, Your Honor, it actually is. The burden is the university has a high burden of demonstrating its compliance with this court's standard under strict scrutiny. The only narrow area that this court's framework, as I understand it, has deferred to the university is establishing its objectives. But the whole framework still requires a well-reasoned explanation for seeking for its own compelling interest. It requires the university to demonstrate that there are no race-neutral alternatives that will work about as well. And so that burden is still heavy on the university to demonstrate compliance with this strict scrutiny framework.